Can a doctor's prior bad acts come into play in your medical malpractice case here in New York? Would you like to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law here in the state of New York. When you bring a medical malpractice case against a doctor, you are claiming that at a particular time, at a particular day, the doctor violated the standard of care, and as a result of that caused you different harms and losses. Now, there are many people who turn around and want to know whether or not, number one, the doctor has been sued before, and number two, they want to know whether those lawsuits have resulted in payment to the patients or an ultimate verdict. The mere fact that somebody has brought a lawsuit against a doctor in the past is not evidence that there was wrongdoing. Clearly, somebody believed that there was something done wrong by the doctor, and the doctor has an opportunity to defend those cases and those claims. And if those cases are settled, we cannot use a prior settlement or the settlement result to show that the doctor deviated or departed or violated standards of care. Why? Because it is not a tool that we are permitted to use as definitive evidence in your particular case. Now, on the other hand, if a doctor took a case and went to verdict and lost, then we can show that to the jury in limited instances, and we can use that specifically, number one, to determine credibility, number two, to establish what the facts were in that particular case, and if they are similar, to then try and relate it to your particular matter. But that's only, again, only if the case went to verdict, and now a jury has rendered a decision, and now whatever appeals are over are finished, and there's a final definitive conclusion to whether or not this doctor was responsible for causing harm to somebody else. Literally, if the two cases are totally different and the facts are totally different, it's going to be very difficult to show that just because the doctor had a lawsuit brought against him and he lost, that somehow translates into meaning that in your particular matter, the doctor did the same thing and violated the standard of care. Although we'd like to show that, we'd like the jury to believe that, the reality is the court will not allow us to create that presumption. So just because somebody has had lawsuits in the past and defended them and settled those cases, that information is not enough for us to use in your particular case. But if a case went to verdict, and now the verdict is final and the appeal is over, and it has definitively been proven that the doctor violated the standard of care that now resulted in harm, and it was similar to what occurred in your particular matter, then in that limited instance, we will be able to show some of those things in your particular case. So why do I share this great information with you? I share it with you just to give you an understanding and an insight into what goes on in the litigation process here in the state of New York. You know, in all likelihood, you have questions or concerns about your own particular matter. Well, if your matter happened here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. This is what I do every single day, and I welcome your call. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's quick video. I'm Gerry Oginski coming to you from New York. Have a wonderful day.